Content warning. This episode contains discussion of murder and rape.
So it's been a good while since we've discussed the University of Idaho murders on the murder sheet. I was thinking maybe it's a good opportunity to look through some of the recent filings, discuss what they mean, and also examine what they could mean for the case going forward. We'll also take some time to review some media coverage of this case and what it may mean for accused killer Bryan Kohberger's family members. My name is Anya Kane. I'm a journalist.
And I'm Kevin Greenlee. I'm an attorney.
We first connected while looking into the Burger Chef murders, an Indiana cold case. Together, we built a spreadsheet documenting hundreds of cases of restaurant-related homicides. That original spreadsheet gave way to our podcast, The Murder Sheet.
Now we maintain that same research-centric, investigative approach as we look into all sorts of homicides, including unsolved cases, historical crimes, and, of course, restaurant murders.
We don't just chat about the headlines. Our podcast is a platform for our journalism. The Murder Sheet focuses on investigative reporting, thoughtful analysis, thorough research, and in-depth interviews.
We're the Murder Sheet.
And this is the University of Idaho murders, social media, Brady Giglio material, and other updates. I just want to do a few quick updates of my own. I wanted to note that in our past coverage of this case, I believe I stated that Bryan Kohberger, who of course is the alleged killer, is a PhD candidate. And a lot of very helpful people, including our cultural correspondent Cindy and a number of great people in our Facebook group, let us know that there's actually a distinction between a PhD candidate and student. It's a bit complicated, but basically a student is still kind of doing coursework. A candidate has done the coursework and is in the process of writing their dissertation. So I was using them interchangeably. That was very much incorrect. And I do apologize for the oversight. We tried to update that episode, but ran into some technical problems. So I just figured I'd just throw that in at the beginning here to say that. And one other correction that I wanted to mention as a matter of pronunciation issues. I believe I pronounced Spokane, Washington as Spokane, like a true outsider. It's Spokane, and I do apologize. Thanks to Heather for flagging that. I think most of the mispronunciations around this part of the world come from me, not you, Kevin. So I do apologize for that. Apologize to the residents of Spokane and all these other places we've mispronounced. I try to look them up, but then I feel like my brain freezes sometimes, and I do appreciate when people let us know so we can correct it going forward and not sound like...
It's very important to us to pronounce people's names and where they live and other such things correctly. And so when we make mistakes, we do appreciate it.
I think I'd be mispronouncing everything here in Indiana with our Indiana cases too if it wasn't for you being like, no, this is this is it. You're my man on the ground here. But then when I get out into the western part of the country, I'm totally I have no guide. I just start saying things. So and anyways, keep the corrections coming. We'll try to get this right, and we do appreciate you guys letting us know. So the first segment of today's episode, we're going to talk about a number of warrants that pertain to social media companies that have been filed in this case, mostly on or around March 23rd and March 24th, 2023. And we'll kind of go over what these are asking for and what they tell us about what the investigation is looking into at this point, and perhaps some of the trove of materials that investigators have been able to compile so far, because this interests me because one of the cases that we cover extensively is, of course, the Delphi case, where social media has a bit of an angle in that case. It's not, we have not proceeded to trial in that case yet, but social media has been kind of like a looming question in that for a while. And I just think, so I think of that as like a social media case in some ways. But some of the filings here indicate that in this day and age, with people using the internet so much, many cases are kind of a social media case, because police are going to want to look through those archives and those materials to see if they can get any evidence, get any indications. So it's almost like, even if, we're not, I think there's been some media chatter around like Instagram or, Kohberger allegedly having potential contact with different victims. But I just think this underscores that like investigators going to be looking at all of that. And that's going to apply to a lot of cases going forward, even ones where you're not like directly linking it with social media, because it just provides evidence. And in the batch that we're about to talk about, it seems like Ann Taylor, who of course is Kohberger's defense attorney, basically moved to file a lot of these under seal or redacted, basically alleging that the documents contain facts or statements that might threaten or endanger the life and safety of individuals, and it is necessary to preserve the right to a fair trial, and disclosure would constitute an unwarranted invasion of personal privacy. So this batch of social media search warrants is heavily redacted as far as what they found, what email addresses or phone numbers they were actually looking at. So keep that in mind. Even with the redactions, I believe it's possible to read in between the lines with some of these filings.
And I think it's important to keep in mind that I think virtually all of us use social media to some extent or another. And just imagine if someone was able to get complete access to your social media. I'm sure all of us have posted things that we would prefer for the world not to see, very personal and private things. We might have also published on our social media things that might affect the privacy of our friends or our colleagues or associates, including, as Anya mentioned, phone numbers and contact information. So a blank check to go through someone's social media and then share that with the world could indeed be prejudicial and damaging.
So on March 14th of this year, there was actually a Zoom hearing in the case. Ashley Jennings appeared for the state of Idaho. She's from the Latah County Prosecutor's Office. And then, of course, Ann Taylor representing Kohberger. The court basically looked through everything, considered the various arguments, and weighed interests regarding both privacy, but also the public's right to know, the public disclosure, essentially. And here's how things came down.
Well, basically, the court decided not to go too far in either keeping it completely sealed or opening it up completely. They sealed it in part, they redacted or edited parts of it, and then they released other parts of it.
Right. So it's kind of a moderate position that the court took on this. Noting that privacy is important, but at the same time, the public's right to know is important. So let's redact the pertinent information that would harm privacy, but release everything else.
And again, I think most people would be nervous or wary if their entire Facebook or Twitter or TikTok history was suddenly going to be shared with the world.
Yeah, it's giving the police the keys to your digital house, so to speak. And frankly, they're probably, given the nature of the internet and human nature as well, I feel like maybe your internet presence might be even wilder than some of the stuff physically in your house, if you think about it. And then basically there were a number of separate filings, all from March 24th, 23rd, that thereabouts, that each dealt with specific social media or internet giants, all based in California. And there were some trends that I noticed about these filings that were a little bit interesting and kind of make for some discussion. The first social media account that police seem to be dealing with in this case, at least in this latest batch of filings, was TikTok, which of course is, they basically stated that they're a company based in Culver City, California. One thing before we get started on that is that The officer in these warrants is Lawrence Mowry. He's a detective based with the Moscow PD. He's a 12-year veteran of the department. He's been there a while. He works the day shift. And basically, it seems like it may have fallen to him with at least the following internet companies, social media giants, to kind of look into them and try to be gathering that evidence, filing those search warrants. He starts with TikTok, and that's not necessarily surprising because we know that there was some reporting that the victims, may have been using TikTok or checking TikTok that night. That may have become apparent to the authorities as they were looking through the victims' phones. And so maybe you want to start there, see what you get. On December 13th, 2022, Mowry obtained a search warrant for TikTok and went to the TikTok law enforcement portal. And then it took a little bit. February 19th, he gets an email from them inviting him to download materials, which he does the following day. And these are TikToks associated with Madison Mogan, Kaylee Gonsalves, and Xana Kernodle. Ethan Chapin is not mentioned in that. It's the three girls that they're really looking at here with their TikToks. And one thing that kind of jumped out to me is like the TikTok law enforcement portal. But actually, each one of the companies that we're going to talk about has such a portal. They, at this point, have some sort of service or liaison that specifically deals with law enforcement requests.
And that in itself is pretty interesting. Certainly, prosecutors have told us that their jobs are a lot easier these days because basically anybody who has a smartphone and uses social media is traveling with a tracker. In that these devices allow people to basically track where all the users go. And I think a lot of people who use those devices and use those services don't fully realize that, for better or for worse. And so that is interesting that we are giving up some aspect of our privacy without maybe being aware of it. It's also interesting that certainly we would agree that in some cases it's absolutely crucial for these companies to share this information with law enforcement. In other cases, it might feel like an invasion of privacy. And so it's a very difficult issue for the courts to sort through and to try to figure out, well, it's okay in this case, it may not be okay in that case. And it sounds like also in many instances, it doesn't even reach a court, that the police just basically ask these companies for this information and it's sent to them.
Yeah, I don't know exactly what these law enforcement portals, what requirements, or if they, it sounds like they're obtaining search warrants prior to going to them, essentially. But it sounds like if you do that and follow the steps, perhaps it's possible to get that information in a relatively timely fashion. Obviously, in this Idaho case, it's very much, I think most people will agree, in my opinion, that this was definitely necessary because it's such a heinous crime, 4 young people losing their lives. But as Kevin said, maybe with lesser crimes going forward, it could be, there could be some controversy around privacy. But certainly in a homicide case, I imagine that in many cases, the social media giants at this point don't want to be seen as aiding and abetting, a murderer escaping. It's interesting. There were technological things. I remember in the San Bernardino mass shooting, where a couple murdered a number of people in a mass shooting in California. In that case, there was a lot of controversy, and it sort of pitted the FBI against, I believe it was Apple, where Apple did not want to help the FBI break into the phone. I'm boiling down the argument. Obviously, it's a pretty nuanced issue, but I think maybe some of these law enforcement portals might be kind of an attempt to say, okay, like, here's how we can avoid some of that public conflict where you have like sides forming, essentially.
These are very complicated issues. There's no easy answers. There's no side that's absolutely right and absolutely wrong. But I think it is worth noting that basically these tech companies, these social media companies have access to a great deal of information about us, all of our private thoughts that we post on social media, and even where we go during the days. And that in some cases, they are sharing that with governmental authorities.
Mm-hmm. The next company that Mowry went to was Google Services, or, Google. And of course, this is based in Mountain View, California. The search warrant for that company was obtained January 24th, 2023. So about over a month after TikTok. And all we know from this is that this came back the same day as the TikTok. So this was a little bit quicker in terms of turnaround, February 19th. He downloaded it February 20th. And under the sort of the inventory and the data, the kind of listed, it's redacted, but we know that they were basically looking at a single Gmail account. Not apparent whose, but just one. Following that, actually just before some of this other data came in on February 15th, Mowry obtained a warrant for Twitter in San Francisco, California. And basically they were looking for basically a number of identifiers that they mentioned, which is a redacted Gmail address, some apparent phone numbers, anything around the homicides of the 4 kids, and the Twitter account of Bryan Kohberger. So at this point, he's very much on the radar. He's the name that they're looking at, and they're wanting to see some of that Twitter activity. Kind of mixed in with a number of these social media search warrants was another search warrant for 1122 King Road in Moscow, Idaho, where, of course, the murders took place. So that's sort of this batch. I will note that this is not the first time that we've seen a whole batch of these orders to seal and redact. And I'll kind of read out to you, I think, some of the companies that they previously were looking at and the dates that these kind of documents came out, because I think they give a bit of a scope of the many different directions that a case like this can take and where officers can really look for evidence and be smart about both sort of the in real life companies and in terms of the, sort of forensics, in terms of the evidence left at the scene, but also in terms of the online and financial components of a crime. So on February 28th, we saw orders to seal and redact for Amazon, American Express, 4 for Apple, 2 for AT&T, Bank of America, Banner Ban, Block, Blue Ridge Knives, Charter Communications, Coeur d'Alene Police Department Forensic Lab, Discovery Bank, Dropbox, 2 for eBay, Elon Financial Services, Idaho Central Credit Union, Idaho Department of Labor, Numerica Credit Union, Potlatch No. 1 Financial Credit Union, Umpqua Bank, and Wells Fargo. Then for March 7th, we had Verizon Wireless, Washington State University, DoorDash, Extreme Networks, 2 for Google, Inland Cellular, K-Bar Knives Inc., 5 for Match Group LLC, 6 for Meta Platforms Inc., Moscow Police Department Forensic Lab, PayPal, Venmo, Reddit, 2 for Snap Inc., 2 for T-Mobile, another 1 for Umpqua Bank, United Parcel Service, aka UPS, another 2 for Verizon, Walmart, Yahoo, Yik Yak. And then March 8th saw 1 for Google. So this has been sort of a slow rolling collection of evidence, and we're sort of seeing that come out through these orders to seal and redact. They're not wanting to put all of that information out to the public at this time, but we are getting a sense of where they're looking and how they could be possibly building up this case against Kohberger. And we're seeing everything from knife companies, which could speak to the murder weapon, specifically K-Bar knives. We know that a knife sheath from K-Bar was found at the scene. We're seeing a lot of social media things, but we're also seeing a lot of financial things. And that could speak to, what's being purchased and whatnot. Idaho Department of Labor intrigues me because it may speak to somebody's employment status. And then, of course, ones that are a bit more obvious include forensic labs. But yeah, that sort of gives you an overview of some of the companies and entities that they have been looking into. And, again, most of this stuff is sealed, it's redacted, so it's not super apparent everything that they're looking into in terms of the details, but it is apparent the directions they're taking. And I think it underscores how robust and thorough their being by basically gathering all this information in order to prosecute a case against Kohberger. But then on the other hand, there was a development recently that perhaps could be interpreted as less positive for the prosecution, maybe a bit more interesting for the defense side of things.
This involves the Brady rule. And I remember when I was in law school, I had the rather silly thought that when you read cases in law books, it's almost like reading Aesop's fables, because you have a little story, the story of the case, and then in the end, you have basically a ruling telling you what it means. And most of you, or many of you, have probably heard about the Brady rule. Maybe you haven't heard the story behind it, and I think telling the story behind it might help illustrate just what the Brady rule is and what it means. So the case in question is Brady versus Maryland. And what happened there was way back in 1958, a guy named John Leal Brady and an acquaintance of his named Charles Boblet committed an act of murder. They killed a 53-year-old man named William Brooks. Now, what's interesting is that Brady and Boblet both admitted their guilt in this crime, and they are tried separately. And both end up being convicted and even sentenced to death. The interesting thing about this is that Brady always denied being the person who personally killed this man. And as a matter of fact, his acquaintance Boblet agreed to that. And he made a statement himself saying that he was the one that committed this murder himself and that Brady did not actually commit the murder. Brady was involved in the underlying offenses. But the prosecution did not tell Brady's lawyers that Boblet had made that statement. And that became an issue. In other words, should the prosecution have to share with defense when they have evidence that might help the defense case in some way? This went all the way to the Supreme Court, and as I'm sure you know, it came down that yes, the prosecution should be obligated to share with defense any information they come across that might bolster the defense case. If you have evidence that would help the defense, you have to share it. You can't hide it, because the ultimate job of a prosecutor is not to secure convictions, and it is not to secure the harshest possible punishment. It is to administer justice. And you don't have justice when potentially exculpatory evidence is withheld.
And for the record, exculpatory evidence refers to what type of evidence exactly?
Exculpatory evidence is basically a fancy way of saying evidence that might help the defense, evidence that might somehow demonstrate that the defendant is not guilty of the crime, or if he is guilty of the crime, he deserves a lesser punishment because you need to consider these facts.
So, like, if me and... I don't know why I always use myself in these examples. If you accused me of stealing your wallet, but then and it was a good case, I had the opportunity, I ended up with a bunch of money that I couldn't account for, but then the prosecution also found out that your neighbor had threatened to steal your wallet and was always talking about stealing your wallet. And that came up in the course of the investigation. That's exculpatory, because that could indicate that your neighbor did it and I was wrongly accused.
Yes.
So it's fair to say, I think, that Brady v. Maryland was a landmark Supreme Court case, because it essentially changed the way prosecutions are done.
It's affected every criminal case in this country since. You always hear about lawyers talking about Brady violations and Brady this or that. And what they're talking about there is maybe the prosecution had evidence that would help us they didn't turn over.
And that's a pretty serious violation, to the point where that could result in convictions getting overturned.
And people being retried. So it's something that everybody takes very seriously, as they should.
And I think it's interesting because some folks, I think, have the impression that, it's kind of like this big grand sword fight between the prosecution and the defense. And, well, why would the prosecution turn over something that helps the defense? Aren't they just trying to win? And, like, that's understandable to think that, given the way a lot of this is portrayed in popular media, and it's kind of glanced over in a lot of things that do focus on crime. But it's very important to stress that, you know, a good prosecutor will err on the side of just giving everything and anything because it's possibly exculpatory, the defense needs to have it, and you do not want to incur a Brady violation because that could undermine any sort of conviction if you do win. Now, I was familiar with the Brady rules. The next one I was not so familiar with. I had actually never heard of this before. You obviously had, but I will be curious if other people following along. I feel like this one's a little bit less well known than Brady.
It's so often the case in legal matters. It becomes very difficult to try to figure out what falls under different categories. And so the court also had to consider, what if a witness is going to be testifying about a crime or an alleged crime, and there's things in that witness's background that might allow the defense to impeach the witness or call the witness's credibility into question or make that witness look bad. And if the prosecution has that information, are they obliged to hand it over to the defense? And in Giglio, the court said, yes, you are. So let's talk about some of the instances where a witness might have some impeaching material in his background. The big one that comes in mind is, let's say, hypothetically, that Anya and her friend commit a crime together, and Anya is promised that if you testify against your friend, you won't be charged. Well, the defense has the right to know about that, because if Anya has a deal to offer testimony in a particular way, because if Anya has a deal to offer testimony implicating someone else, that gives her a motivation to potentially lie.
Wow, I'm such a snitch. So basically, these are fundamentally about protecting an accused person's rights in court and basically making it so the prosecution can't get away with necessarily doing things without the defense knowing about it to win.
In the situation I just mentioned, perhaps Anya got that deal to offer testimony, but her testimony is still truthful.
Yeah.
Just because you have a deal doesn't mean you're lying. But still, the defense and ultimately the jury should have the right to have that information to add it to the scales one way or the other when they're trying to figure out who's telling the truth or who's lying. So in other words, just because a witness has some Giglio material in their background, just because there's something about them that might cause potentially their testimony to be impeached, that does not necessarily mean that they are lying or cannot be trusted.
Are Brady and Giglio therefore typically grouped together because although they're doing different things, they're sort of related?
Yeah, they're often grouped together because Giglio basically falls under Brady. Brady creates an obligation to turn over any exculpatory material, and Giglio says, well, here's one way we define exculpatory material. If you can impeach somebody with particular bits of information, you need to turn that over, even if it's not directly related to the subject matter of the case. And again, just because someone potentially can be impeached does not mean that person is lying. I really want to stress that before we get too much further.
Right. You do have situations where the prosecution, in order to strategize or perhaps because they're mitigating factors, will offer one person a deal if multiple people are involved in a crime, and that just ends up making sense. And the jury can weigh that themselves and say, well, their statement is still corroborated by this other evidence and therefore seems reasonable, or, oh, I'm pretty sure this is a pretty thin case and these people are incentivized to lie. So it sounds like it's more about leveling the playing field. So there's no surprises, and that people are not kind of jurors and not led to believe, wow, this person is completely, on the level, when they may have a motivation that's just not being disclosed.
And this potentially impeachable witness, the stuff in their background, doesn't have to be something like a deal with the prosecution. It can be something else. And what is it in this case?
Well, on March 27th, 2023, the Latah County Prosecuting Attorney's Office basically flagged with the defense Brady Giglio issues, namely that one of the officers involved in the case against Kohberger has been the subject of a confidential internal affairs investigation.
And that falls under Giglio, because Giglio says that anytime the reliability of a witness may be determinative of guilt or innocence, non-disclosure of evidence affecting the credibility of that witness falls within the scope of Brady. You have to disclose it. And we don't know who this officer is. We don't know what the internal affairs investigation is, what he's alleged to have done. We don't know the results of that investigation. I think we can all agree that if the police are investigating one of their own because that person has been alleged to have done something improper, that could potentially call that officer's testimony and credibility into question. In other words, if someone is accused of violating departmental rules or whatever, then perhaps that person is slipshod in other ways. Perhaps that person is sloppy. Perhaps that person's word can't be trusted. Now, with that said, I think we can all imagine cases where if a person commits a violation of a police department's protocol, it doesn't really affect their credibility in the long run. Maybe they filled out some paperwork incorrectly or made some sort of mistake. That's basically trivial. But we can also imagine situations where a person is alleged to have done something much worse than that calls into question his integrity. And if a person lies in one area and commits violations in one area, perhaps he's committed violations in others.
Here's a question that I think a lot of people might be wondering. Does this mean that somebody in this particular investigation incurred an internal affairs investigation over their conduct in the Idaho case, in the University of Idaho murders? Or could this be about something else completely in terms of, other cases they've worked, other activities they've been doing in the department?
This does not specifically say it's about Idaho, so it could be about any case.
Right. So I'm just trying to underscore that it's really unclear. This could have a lot to do with the University of Idaho murders. It could have very little to do. As you said, it could completely impeach the person, make them seem not credible at all, or it could not really have much of an impact if they're either completely cleared by the IA investigation or it turns out to be a somewhat minor affair or not touching upon their credibility.
And basically what it means, what these court rulings stand for, is it's not up for the prosecution to determine, well, this particular internal affairs investigation doesn't affect his credibility. We don't need to even mention it. They have to mention it. It's up for the defense and ultimately the judge and jury to determine on their own whether or not something like an internal affairs investigation ultimately affect the credibility of the officer's testimony.
Right. And based on this document, we're also unlikely to find out what the nature of this internal affairs investigation is for quite a while, because the prosecution asked for that to be sealed, essentially. And Magistrate Judge Megan E. Marshall did seal it, and basically they do not want those documents or the contents thereof getting out there unless it is eventually authorized by the court. So we probably won't necessarily know about that or the relevance. I think it's been couched as like this could be bad for the prosecution. That's certainly true, but I think it's also important to remember that without knowing more about the investigation, this internal affairs investigation, it's sort of hard to say how relevant it would be. Also, one note, Moscow Police Department seems to be a pretty, it's not a huge, massive, big city police department. So I imagine a lot of different people were working on this case. You know, we've seen different officers' names pop up in some of these documents. And so one thing that is important to remember is it's not clear how much this particular, it's first of all not clear who this person is, but also secondly, how much they worked or how much, you know, they influenced this case at this point. If it's somebody who kind of did a few side tasks, then that's going to be different than somebody who is maybe considered one of the lead investigators, essentially.
Yes, although just to speculate, they're talking about the whole issue is whether or not this affects the credibility of a witness. And so whoever this officer is must be someone who they feel potentially may be offering testimony at the trial. So that suggests that perhaps this person had a crucial role in at least some aspect of the investigation. But again, that's just speculation.
So the last segment that I wanted to go through with you is not actually legal in nature. It's more of a media angle that's kind of formed. I've seen it in a number of different publications that have covered the Idaho case. Basically, a report noting that Bryan Kohberger's two sisters, Melissa and Amanda, have lost their jobs over their connection with Kohberger, and that therefore the family is being financially harmed by their association with this case. And I found this interesting. I guess, I mean, to note, to kind of have a huge caveat here, we've not confirmed this information ourselves, whether it's true or not. A lot of news outlets, including news outlets that we do respect, did run with it. So I'm inclined to say, you know, that's interesting, that's significant. But a lot of the reporting was somewhat thin. And by thin, I mean nobody made it clear what entities, quote unquote, terminated or fired these women. It was not clear, like, the circumstances. It just kind of notes they lost their jobs over their connection with Kohberger. And so when you have a report like that, where there's not a lot of details, there's not a lot of color on what exactly happened or who was involved, what entities, what people, then that kind of, that leaves something to be desired, because it's difficult to, you know, basically double check that. And notably, both of these sisters, one works as a mental health professional and the other works as an actor. And in both of those cases, it's not apparent to me from what research I did what specific projects or companies they would be associated with that would then subsequently be in a position to let them go. I could understand maybe a situation where people who are more in the freelancing position are denied work or feeling that they're denied work because of their association with Kohberger and therefore not getting money. But like, that's not a termination. That's not a firing. That's just more of like work drying up. So I don't know. I still have some questions about the whole thing, I guess. The reason I wanted to speak to it is because if it is true, that's disturbing to me, to be honest. Having people be ostracized or harmed professionally because of a connection with somebody who is accused of doing horrible things, that feels, I don't know. That do we want to be a society where that's going on? I mean, and here's my thoughts on it. Like, in a situation where the perpetrator's family's conduct relates directly to the crimes they committed, let me give a hypothetical example. Let's say a serial killer who's very violent, kills a bunch of people, turns out to have been severely abused by his parents growing up, and it hindered his development. And, you know, there's this kind of well of violence that kind of perpetuates the whole thing. In that situation, if people want to judge those parents for, you know, by being violent towards their child, essentially creating a set of basically triggers that may have shaped the kid into an adult who preyed upon other people, yeah, I can get on board with that. You know, I mean, like that seems fair to me. You know, basically child abuse leading to something horrible or other forms of, you know, situations. And then alternatively, if a family of a person who is charged with heinous crimes or convicted of heinous crimes continuously either directly aids and abets the person in their crimes, or at the very least kind of strives to cover up, situations to benefit them and is constantly bailing them out. Yeah, I can understand some judgment in that case. One that comes to mind is actually in the Burger Chef murders that Kevin and I have worked on. There's a figure named Donald Forrester who, falsely confessed to the crime multiple times. We do not believe he actually committed the murders, but he's a pretty heinous person in his own set of crimes that he was convicted of. He was sentenced 95 years for a very, very horrible rape that I think most people think would have turned into a murder had the victim not escaped. Now, I bring up Forrester because his family, or members of his family, I should say, not universally, not everybody in his family, that's a key thing here, but some members of his family would kind of get him out of mental asylums when he got, thrown in there, would bail him out of jail, would defend him from other family members who were trying to either get him help or kind of get him out of their lives because he was being so abusive and violent. This group of men within his family would basically aid and abet him. And then when he was on trial for rape, these family members were also calling the victim, calling various people associated with the case, were making threats to all these people in an attempt to get him, out of jail, in an attempt to basically cover up his crimes. So when people are doing that, yes, shun those people. That's horrible. But when it's a situation where you happen to be siblings with somebody who is accused of doing something horrible, and, we haven't even had a trial yet, and there's no outward indications that these sisters knew anything about what he was doing or, would have aided and abetted him, or, that just seems preposterous to me that if they're being shunned and denied an opportunity to earn a living, I don't know. That's like retribution against the wrong people. I don't know. That just strikes me as pretty horrible. What do you think?
I completely agree. It's just important not to blame people for what family members of theirs happen to do. Let's just focus on the real perpetrators. And also it's important to remember at this point, Kohberger hasn't even been found guilty in a court of law.
Yeah. There's this tendency on the internet, especially to just weigh in with zero facts or very limited facts. And I think that's harmful when you're basically casting judgment on people, when you're saying things like, oh, his sister must have known. Why do you assume that? Do you have any sources close to the investigation that are saying that? Or are you just, some keyboard warrior? And I think most of the time it's the keyboard warriors. It's not somebody with actual information. And it's just this rush to judgment and punish anybody associated with somebody who's accused of something. It's just, I think it's meant to help people deal with the fear of how could this person randomly have done such horrible things? It's first of all, he hasn't been convicted yet. Second of all, I don't know, just calm down, everybody. You can always later on, if it turns out that a perpetrator or an alleged perpetrator's family directly helped them, you can always criticize them or scrutinize them or talk about that later on. You can always hold that for when you actually have some evidence or there's other charges or something else is going on. You don't need to just, shoot off your, first angry thought on the internet, because the people at the heart of these cases are real people. And how would you feel if somebody connected to you did something horrible and then people were, digging up your life and saying that you should be denied employment? That would not be a fun thing.
Anya, you and I both have siblings. We're not criminals. They're not criminals, but I know each of us have done things our siblings don't know about. I'm certain they've done things we don't know about. And it's just not appropriate or fair to blame a sibling for something that their sibling may have done. They have no power or control over.
Yeah, I completely agree. I think people on social media need to think about, do you co-sign everything your sibling does? Or do they co-sign everything you do? I doubt that. I think when people are adults living their own lives, you can have a relationship without necessarily being deeply involved in every aspect of your sibling's life and being aware of what they're doing, good and bad. I think a lot of people are thoughtful about that and will kind of say, hey, let's not do a rush to judgment. And I feel like a lot of our audience is very much in that mindset. And that's why we appreciate you guys, because I feel like there is that kind of like, let's withhold judgment for now and maybe forever if there's no evidence that it's warranted. But I think on some of the social media platforms where it's basically, there's no repercussions to being anonymous and saying horrible things about people and, then just moving on with your life, there isn't that same, because there's no penalty to just saying, oh yes, get these people fired. And I think I don't think that advances these cases. I don't think it does anything other than punish people who don't deserve it. All right, so I think that kind of clears up most of the Idaho items that we hadn't gotten to recently. The case is ongoing. We'll continue to sort of check back with some of the legal filings and see if we can have any interesting discussions. And we hope that these episodes and these discussions give you a greater understanding of some of the laws underpinning this process, and therefore helps you understand our sometimes complicated and confusing, adversarial, and imperfect, but still very interesting legal system.
Thanks so much for listening to the Murder Sheet. If you have a tip concerning one of the cases we cover, please email us at murdersheet@gmail.com. If you have actionable information about an unsolved crime, please report it to the appropriate authorities.
If you're interested in joining our Patreon, that's available at www.patreon.com/murdersheet. If you want to tip us a bit of money for records requests, you can do so at www.buymeacoffee.com/murdersheet. We very much appreciate any support.
Special thanks to Kevin Tyler Greenlee, who composed the music for the Murder Sheet, and who you can find on the web at kevintg.com.
If you're looking to talk with other listeners about a case we've covered, you can join the Murder Sheet discussion group on Facebook. We mostly focus our time on research and reporting, so we're not on social media much. We do try to check our email account, but we ask for patience as we often receive a lot of messages. Thanks again for listening.